application requirements for owners of multiple facilities. And the other change that was significant in there was the signatory requirement to meet the 40 CFR 122.22 EPA requirement with regards to MPDS signatures during the application process. So as required by the EPA for the National Pollution Elimination Discharge System e-reporting rule, the signatory requirements were amended back in 2019. So we made those amendments to our regulations to allow for electronic signatures for permit applications so that they can electronically submit applications. This proposal maintains our program's permitting process in compliance with the EPA's MPDS requirements. After a recent district court ruling, some of the language that was in this part 4 here was under review that was really unclear about how two individual owners of two confined feeding facilities on separate tracts would need to be considered a single or multiple facilities. Under this proposal, it makes it more clear that an owner of a confined feeding facility does not have to search the property records to find ascertain the location of any adjoining properties that might contain feeding facilities, and whether or not there was a connection to the applicant and no shared waste management systems were there. The proposed language provides a more prescriptive definition of the separate and single confined feeding facility as defined by the statute. Basically trying to take the more ambiguous, very open definition that was there before and provide a more descriptive one. The clarification of this definition does not impact the permitting requirements, will not alter any of the existing habitable structure separation distances, separations to groundwater or surface water. However, the clarification could require two or more confined feeding facilities that do have a combined shared waste management system to be combined under a single permit. Our current permitting requirements require an engineer review of each waste management system prior to and after construction. These requirements remain unchanged. The focus of this proposed language is the separateness of each livestock waste management system to ensure that a single party is responsible for maintaining and operating the waste management system in compliance with the permit. As mentioned, there's no changes to our permitting process and review from the engineering and technical standards. This was drafted in response to more clearly define the final language that was in this regulation that was previously there, as well to maintain the interpretation that has been historically and consistently been upheld through the years to maintain things that continue to be done the same way.
Okay, are there any questions or comments on this? Yes, Senator Corson.
Thank you, Madam Chair. I had some folks reach out to me with sort of some concerns about this, and to summarize it, it was essentially that a concern that maybe these changes would allow multiple facilities in a single location to evade longer setback distances from habitable structures and surface waters, although the density of the animal units would not be changed. Can you just speak to that a little bit? And also, if you could talk about maybe some of the outreach that you did to stakeholder groups in advance of putting together these proposals. Thank you very much.
Thank you. So the intent here was to clarify what had been previously always done, saying you've got to go through the permitting process. Permit is reviewed, checked for, do you meet all the requirements? And after this ruling, the main concern that we were getting from the industry was that, depending on how you read that interpretation and how this could be changed, would be that if I owned a facility and my neighbor right across the fence line owned another permitted facility, and I bought his facility because he went out in retirement, that there are some interpretations to this that now, I would now have to take that previously permitted historical facility, combine it to mine, whereas they have always been operated, they had been built, designed, and permitted as single facilities. The intent is the protection of what has been historically there, not the development of this ability to build a next door and a next door and a next door. Was to clarify what had been previously done if the next facility had been brought. And so with that in the consultation, was with review with the livestock industry. That was their primary concern as we were going through and trying to develop not so much a new set of regulations to change everything, but to just clarify the definition that was there and we've already been following throughout the years with our stakeholders.
Yes, go ahead.
And did you talk to any other stakeholders other than industry groups, folks kind of concerned with rural living or environmental groups? Is kind of my first question. And then my second, I'll just ask it now. It would be, I understand the intent, but could the effect be to have the same density, but not the same setback requirements? The same density of animal units in a given area without maintaining those setback requirements. Could that be a possible effect of it, even if that maybe was not the intent, possibly? And I'm sorry that those are two very different questions, but I appreciate your indulgence and thank you very much.
So with the stakeholders, no, they've been through throughout the time we'd heard from various people, but not any of the other specific groups that you mentioned. With regards to the density, because of the engineering requirements, it would not promote that change to require allowing that density thing to just increase like you're proposing there.
Just one more question, if I could, Madam Chair. Could you just explain for maybe for the committee? I know I certainly am not familiar with it. Could you talk about that? There was a kind of a court decision that I think was sort of the impetus for maybe this change. Can you just talk, just so all of us are aware of, just have a background and understanding of sort of the issue there and what the court held? That just might be helpful. I'm speaking for myself, but also maybe for other committee members. Thank you very much.
Yes, I'm going to have David Cohen, our attorney that's more familiar with speaking on that, address that for you.
Hi, everyone. My name is David Cohen. Yeah, I can talk to you about the court decision. The issue was whether two hog facilities with separate waste management systems that were touching and had should count as one or two facilities for purposes of setback. In the statutes and regulations, the more hogs you have in the facility, the further setback you need from one. And so if those two were to be combined, they would have had to been set back further. The regulation in question, and the one we're amending, had to do with what was the phrase? Yeah, contiguous ownership versus, and we said, in our interpretation, we said contiguous ownership boundary. And the judge took issue with that, and the judge said because they touched, that they had continuous ownership boundaries and they should be counted together, and therefore requiring a larger setback distance from water than they currently have. So that is the case that sort of spawned this.
Does that answer your question, Senator?
That does, Madam Chair, and I appreciate you letting me ask several questions, and that's all I have, and I thank you very much. Thank you.
I also appreciate your asking that, because I was wondering what the legislation was, or the court case was as well. So thank you. Are there any other questions or comments? Not seeing any. Thank you so much for being here and with us on WebEx. We'll move on to the State Employees Healthcare Commission.
Good morning, Madam Chair and committee members. I'm Janet Stanek, and I am the Director of the State Employee Health Plan. And with me in the room is Mike Michael, my Deputy Director. We are here to present on 108-1-1, 108-1-3, and 108-1-4, all with the same purpose. The regulation that's being proposed is amended to eliminate the current 30-day wait period prior to becoming eligible for enrollment in the healthcare benefits program with the plan. With the change, each person will become eligible for benefits beginning with their employment date, day one. This change was not mandated by law, but came about in response to the request of the employees and agencies. And I'm presenting these changes on behalf of the Healthcare Commission's recommendation. And I'll entertain any questions and stop there. Thank you.
Are there any questions or comments? Representative Wagner.
Yes, I run a private business, and this sounds very unusual that a company would actually start somebody immediately on their healthcare plan. I mean, that you do have people who, for various reasons, when they've been there for a week or two, it's not working out, you know, they flame out. And I mean, having a 30 or 60-day start has always, I have always thought at least, was considered a very reasonable business practice. And I'm a little surprised that you're going this opposite direction. I mean, was it just you had some employee that they would like it to start? And, you know, I mean, there is an additional cost, obviously. I mean, you're going to be picking up your share of the health insurance 30 days earlier for people than you would, or 30 or 60 days earlier. Do you have an estimated cost on this as well? I mean, can you explain this a little more?
Yes, thank you. This was done primarily from a recruitment and retention perspective, and to be an attraction to join the state plan. The turnover and the odds of people quitting within that time period were discussed, but it's a risk-benefit balance, I guess is what I would describe it as. The fiscal note that we had created to review what this would cost the plan and the state resulted in less than about $300,000, perhaps more, for the employer, us, the state, and on the employee side, $95,122, less than $400,000. And that I need to put an asterisk by that because it's based on the estimated turnover rate and vacancy factor, basically, which means on average, when an employee leaves employment, it takes about an average of 4.25 weeks in a month to fill that position. So you have some vacancy there.
Absolutely.
Can I ask, did you do any sort of like peer testing? I mean, you know, Blue Cross Blue Shield, other big employers in town. I mean, well, actually, they might be the oddball, but you know, other major, you know, manufacturing companies, you know, like your Frito-Lay, your M&M plant, or your Mars plant. I mean, do they do this? Again, I'm really asking. In the small business world, this would be totally unusual.
I believe that you are correct that it in this region, I would say it might be unique, but throughout the country and on the West Coast and so forth, it's not as much. I don't have any specific numbers for you of what various employers in our competitive market offer in this regard. I think our actuaries would tell you 30 days is something they see typically. But back to the purpose of this, and one of the key drivers, it is to attract talent to the state personnel pool.
Are there any other questions or comments? I will say I was a little shocked at this when private businesses cannot do this, when they might want to do it in order to recruit people as well, but it's not an insignificant amount to the state. I mean, it's close to $500,000. So I'm a little surprised, maybe more so than I'm letting on, that you're barreling ahead with this. So now every private employer who can't get employees because they're making so much in unemployment don't have a tool to get people in as well. So, yes, Senator Fauske-Dole.
Madam Chair, so to the speaker conferee, so those that might come to you if they aren't hired or employed, will you then kind of refer them to the private companies that the chairman's speaking of?
Are you talking to me, ma'am?
Yes.
Okay, sorry. I just started in September, so this is my first hearing with you all. So thank you. I don't do the hiring. The personnel department does the hiring. We simply do the benefit plan, administer the benefits. So this is kind of a combined joint effort related to recruitment, retention, and our ability in my area to execute on getting those benefits rolled out day one to a new employee. Does that help you?
Well, I just was kind of thinking, is there a possibility that those that don't, because I would imagine with this incentive, you would get a lot of people applying. Is it a possibility that you might have a list if private businesses were to share with you that you could then refer them to that private employer?
I think
I don't
that's a
know.
great
Thank you.
idea. A great idea. I sure can talk to the personnel director in the Department of Administration about what our process is currently. I'm not as familiar with that process right this minute, but I'll pass that on.
Representative Wagner, please.
Thank you, Madam Chairman, for another question. As I'm reading through this, this also, it doesn't just apply to the state government. It looks like this applies to school districts and local levels of government. Is that correct?
Yes, I apologize for not reading. When I read the numbers of the statutes, 10811 covers the state employees, 10813,
okay.
yeah,
Okay.
school
Okay.
district, and yeah, so sorry about that. And then the local unit employees are non-state group members who we all
Okay.
cover the plan. Mhm.
Okay. If I can continue with the question, then I guess you're going to cover it. What is going to be the cost of that? I mean, that's not figured into your cost statement is strictly regarding the state government, but you're actually incurring a lot of additional costs on school boards and, city and county governments. Are you not?
Yes, and I can read that from a school perspective. The cost for both employer-employee total is a little over $56,000. And then for the public employer, it's about $85,000. And for these,
Yeah,
go ahead.
no, that couldn't be correct. I mean, the number of employees for school districts across Kansas is decidedly greater than what you have as far as state employees. I mean, the number would have to be larger, would it not?
Hang on a second, sir.
Thank you.
Sir, we do not have all of the school districts, only some that elect by, through our contract. So right now, the number, I'm looking here, the numbers that are hired, for example, I have the numbers hired by school groups in 2019, which are our baseline, and there was 167 employees, for example. So it's not all school districts.
Absolutely, go ahead.
Just for point of clarification, so not all school districts do their health insurance through you, that would be the reason it would be, so it's only the ones that do their health insurance through
Yes.
you that would be, All right.
Yes, it's only,
Thank-
yes, it's only the ones that are covered by the plan.
Okay.
Our plan, state plan.
Did that answer your question? All right, is there any other question or comment? Did you have? Representative Newland.
Thank you, Madam Chair. Would that include the universities also then?
Yes, sir.
Okay, thank you.
Mhm.
Okay, is there any other question or comment? We can obviously add comments at the end of the meeting. If you have some comments on this to put on the record.
Thank you.
All right, thank you very much, Janet. I appreciate, I think you went over what the other three things were, which expands the cost. If you, I would ask you at this point to make sure that you get those cost figures back to us.
Oh, okay,
I would appreciate that for all of them and broken down.
will do. Yes,
Thank
will
you.
do. Mhm.
Thank you very much. Does anyone else have anything at this point for this? If not, then we'll go ahead and we will move on to the Department of Administration. Do we have anyone?
Sorry about that. Madam Chair,
Okay.
members of the committee, John Yeary, Chief Counsel, Kansas Department of Administration.
Thank you for being here.
Thank you. Here to talk about 1181A, which is mileage reimbursement rates for traveling on state business in a privately owned conveyance, a private vehicle. Really just trying to streamline and update this regulation and also add some discretion for appointing authorities to take into factors other than cost. Under the existing regulation, if a lower cost mode of transportation is available, state employees were limited to that rate. But it failed to take into consideration things like, proximity to the rental car or which direction that might be if you're traveling. So this would allow appointing authorities to consider those types of things in determining whether or not to allow the mileage rate at the IRS rate or the rental car rate, which can be required. So, and then 118.2 is just being revoked as out of date.
All right. My first question is just, it's still staying with the federal government mileage reimbursement rate, correct?
Correct. Yes, by statute, that's required. We post an information circular that updates those rates from time to time as the IRS updates those rates.
All right. Does anyone have any questions for Mr. Yeary? Did I say your last name correctly?
You did, yes.
Good. Oh, phew. I lucked out on that one. All right. I don't see any questions online and I don't see any here. So I thank you for being with us. I appreciate it. At this
Likewise, thank
point,
you.
while we have a quorum, let's get back to the minutes quickly and take care of those. Does anyone have any changes or corrections to the minutes? If not, do we need to vote? We need to vote on approval of a minute, so I'll need a motion. Senator- Okay, Representative Newland is made the motion and Senator Corson made the second. Okay, all those in favor? Aye. Aye. Opposed, same sign. Minutes are approved. Thank you very much. Is there any other comment or notes that we want to put on this to go over before we finish this meeting?
The, just, I suppose, I think it should be duly noted, just the unusualness of what the state health plan is proposing to be done. And I mean, even in their data from other states, if you look at it, all of them have over 30-day waiting periods. I mean, why Kansas would somehow jump the gun and, you know, and start from the first day of employment, particularly given the fact that, what if you start on the 15th of the month or something? I mean, I don't know. It just seems like you're asking for trouble, and this is ill-conceived, in my humble opinion.
I have to agree with you. Thank you. Representative Newland.
Thank you, Madam Chair. And I would agree also. I think it's undue fair practice against our private industry. And so I would concur with the representative.
Okay. Does anyone else want to make any kind of statements in this? I have to agree with the two representatives that spoke about that. I just find it astonishing. And we're at a point in this procedure that we can't stop them, which is very disconcerting to me, that we can't make them go back and consider this. So I would like to make a note as well that the chair is unhappy with this decision, and I think it was ill-conceived as well. Are there any other comments or concerns that one would like to bring to this meeting? Senator Warren.
Thank you, Madam Chair. Just want to comment further about the three representatives who have commented today on that. We're hearing from private business that they're having trouble getting folks back to work, to come back to work, and restaurants and other hospitality concerns back in my district, and I think across the state, are having trouble getting people to come back to work. So we've got to find better avenues to have them be incentivized to come to work. And this maybe then creates a little bit of a disparity in coming back to work for private business versus coming to work for the state. And often it's the folks in private business who lost their employment as a result of the pandemic, and the legislature is taking other action to help those businesses. And it's a bit troubling that we are where we are on this particular issue on the insurance with the state folks. Thank you.
All right, yes, Senator Corson.
Thank you, Madam Chair. And not to necessarily be taking a different side, but I would just offer, one thought is just that we've seen that, salaries for state employees have not necessarily always, been increased. And there's just kind of a narrower band of incentives that state is able to offer employees compared to the private sector, where there are just more carrots that are able to be offered. So I think that's maybe just a different, something to throw into the mix, not necessarily to necessarily disagree with anything that's been previously said, but just sort of acknowledging that, state government only has so many tools in the toolbox, so to speak, of things that they're able to offer to employees versus, a private company that kind of can do more or less what they want in terms of incentives. So just another way to maybe think about it. I wanted to offer that to the mix. Thank you.
Thank you so much for your comment. Joel, you had something you needed to add.
One of my colleagues who is listening in pointed me to House Bill 2218. That bill expands the commission from the State Employee Health Care Commission from 5 to 7 members by adding 1 member of the Senate Committee on Ways and Means, appointed by and to serve at the pleasure of the President of the Senate, and 1 member of the House Committee on Appropriations, appointed by and to serve at the pleasure of the Speaker.
All right, thank you very much for drawing attention to that. Senator Warren.
Thank you, Madam Chair. And certainly we appreciate our state employees and all they do. And we can't operate as a state without them as well. So not meaning to not be thankful and grateful for their work as well, our teachers and others who serve our state well. And it's not entirely correct that private employers can do whatever they want regarding employee benefits and things. It's a heavily regulated area as well. So it just needs to be I would assert a better balance, and I think that was some of the concerns raised here today. Thank you.
All right, thank you very much. Is there anything else for the good of the committee? If not, I think we're finished with business, and I call this meeting adjourned. Thank you for being here.